to go straight to the office of the DPP, where we understand he's just about to address members of the press. Let's cross over there live and listen in.
Okay. So I have two statements to make today, and I'll start with the first one. So I wish to state the following in relation to the decision rendered in Malindi High Court by the learned Honorable Mr. Justice Reuben Nyakundi in Mombasa Constitutional Petition number 143 and 145 of 2019, prohibiting the prosecution of the learned Mr. Edgar Kangoni, Magistrate Mr. Edgar Kangoni. Let it be known without any iota of doubt that as an office we respect the decision of the Honorable Mr. Justice Reuben Nyakundi, but do not agree with the reasoning and application of the law, more specifically in regard to judicial independence and immunity. It cannot be gainsaid that officials in the public service who, in the discharge of their public duty in good faith and in obedience of the law, enjoy some measure of immunity. However, that immunity does not extend to acts that are manifestly criminal and or done outside the realm of the performance of their public duty. In this regard, I wish to state without any fear of contradiction that judicial officers in the Mombasa law courts, being public officials and in the discharge of their duties, committed acts that, in my view, based on the evidence before me, were criminal, and that all the officers concerned must take responsibility and bear the consequences as envisaged under the law. It is the spirit of the above reasoning and rationale that I find the decision to terminate the proceedings against the Honorable Magistrate while upholding the decision to prosecute the other judicial officers together with whom he had been charged most appalling, despicable, and unfathomable, and a threat to the independence of the Office of the Director of Public Prosecutions in making prosecutorial decisions. The failure to observe and uphold constitutionalism is not only a threat but a sure guarantee to our constitutional decay and disintegration that we must all collectively avoid at all costs. It is tried law that parties are bound by their pleadings and the evidence that they present in support of such pleadings. But the emerging trend in our courts is worrying, in that judges have embarked on a soul journey of judicial craft and innovation by granting parties reliefs that are either not sought nor proven. For example, in the instant case, the Honorable Judge condemned the Office of the Director of Public Prosecution to pay damages of Kenya shillings 2 million to the magistrate without any factual or legal basis at all. In order to ensure that the Constitution is not subverted and replaced with individualistic consideration, this office will be appealing the decision of the High Court, barring the prosecution of the learned magistrate, and will not hesitate in future to make our decisions where there is evidence to prosecute anyone that is culpable of any criminal act or omission. That is our infinite promise to Kenyans, and we call upon all Kenyans of goodwill to support us in this regard. In making this statement, I am aware that judicial craft and innovation has emboldened persons charged with criminal cases to threaten to defy court orders in the hope that our courts shall protect them and shield them from the criminal justice process. This has seen other arms of government to disregard the rule of law and doctrine of separation of powers. The media reports on the Senate's action to disregard court orders and direct Governor Waitutu to open a parallel office, well aware that the High Court has pronounced itself on this question, is worrying. This office shall remain vigilant, and such atrocious acts shall not go unpunished, no matter what the individuals involved shall endeavor to do. And I'm warning both Honorable Waititu and the Governor of Samburu not to break the bail terms that they are under, and we shall take action and arrest them if they do. To avert a constitutional paralysis and malaise, organs of government charged with law enforcement must be prepared to wage a consistent, robust, and ruthless war against all forms of crime in order to secure the future of our children. We shall not be intimidated. Thank you. Now, on to my next statement. Thank you, everyone, for coming. Following a comprehensive investigation by the Ethics and Anti-Corruption Commission, and upon receiving and independently reviewing the investigation file, I have found sufficient evidence to warrant prosecution, and I have therefore ordered for the immediate arrest and arraignment in court of the Governor of Nairobi, Honorable Mike Mbuvi Sonko, and other persons for the crimes of conflict of interest arising from having received monies from the County of Nairobi while serving as governor, unlawful acquisition of public property, money laundering, and other economic crimes. Investigation into these crimes have been challenging because of the repeated attempts by the accused to obstruct the course of the investigations by deploying intimidation tactics, in addition to using goons to threaten law enforcement officials carrying out their constitutional mandates. The investigation by Ethics and Anti-Corruption Commission uncovered numerous instances of criminal conduct and a general disregard of the law by the governor and others being charged. Put simply, the action of the accused showed a blatant disregard for laws. The accused persons placed their own interests ahead of the residents of Nairobi. This constitutes a clear and reprehensible abuse of the public trust. Public officials should be role models for the citizens they serve by adhering to the highest standards, to the highest of standards. These individuals being charged today chose to break laws, actions for which they must be held accountable in order to preserve the public trust and confidence. Whenever public trust is betrayed by those in positions of authority, by misusing their privilege to conspire, connive, and commit crimes against the people, our laws expressly mandate the law enforcement agencies and the Office of the Director of Public Prosecutions to step up and safeguard the public good and interest. Today's decision to charge underscores the fact that the Office of the Director of Public Prosecutions remains firmly committed to safeguarding the citizens of Kenya and combating fraud and crime in all its forms. No one, nor any entity is above the law, and we will never tolerate activities like the criminal conduct at issue in these charges. That is why the Office of the Director of Public Prosecution will continue to direct investigative agencies to meticulously and deliberately investigate any such matters brought to our attention, using every tool, resource, and legal authority at our disposal to ensure that justice is served to the Kenyan people. We are committed to bringing to justice individuals who misuse their official positions and line their own pockets with millions of shillings of taxpayers' funds for their own greed at the expense of the Kenyan taxpayers. Having reviewed the inquiry file, I am satisfied that there is sufficient evidence establishing criminal culpability on the part of the following suspects, and consequently, I have today directed the EACC to effect the immediate arraignment before court of the accused persons named herein below. Officers from the Nairobi City County Government who facilitated and or benefited from the irregular procurement and payments amounting to Kenya shillings 399 million shillings. 1. Kioko Mike Sonko Mbuvi Gideon, Nairobi City County Governor. Peter Mbugwa Karioki, County Secretary. Patrick Mwagangi, Head Supply Chain Management. Samuel Ndungu Mwangi, Member of the Negotiation Tender Opening and Evaluation Committee. Edwin Karioki Murimi, Member of the Negotiation Tender Opening and Evaluation Committee. Lawrence Mwangi Mukuru, Member of the Negotiation Tender Opening and Evaluation Committee. Preston Mwandiki Miriti, Member of the Negotiation Tender Opening and Evaluation Committee. Wambua Ndaka, senior clerical officers of the Nairobi City County. Andu Nasiego, also a senior clerical officer. Private persons and business entities who benefited from funds irregularly acquired from the Nairobi City County government. Anthony Mwaura Nganga, Director, Haji Enterprises Limited and Todi Civil Engineering Limited. Rose Njeri Nganga, Director, Haji Enterprise Limited and Todi Civil Engineering Limited. Haji Enterprises Limited, Todi Civil Engineering Limited, Arbab Auto Limited, Rogue Security Limited, High Energy Petroleum Limited, and Anthony Otieno Ombok, Director, Rogue Security Limited, Arbab Auto Limited, and High Energy Petroleum Limited. Upon further review, I also found that the following persons and business entities contracted by Nairobi City Council Government, Nairobi City County Government, in delivery of various services to the county are criminally culpable for money laundering to a tune of Kenya shillings 24.1 million. 1. Web Tribe Limited. Danson Mushemi Njunji, Director, Web Tribe. Robert Murithi Muna, Director, Web Tribe. Zablon Onyango Ochomo, Agent, Web Tribe Limited. Frederick Odhiambo, alias Fred Oyugi, Partner at Yiro Enterprises. In this regard, I direct that the above quoted person and business entities be charged with the following offenses: conspiracy to commit an offense of corruption contrary to Section 47A of the Anti-Corruption and Economic Crimes Act. Willful failure to comply with law relating to procurement contrary to Section 45 2B as read with Section 48 of the Anti-Corruption Economic Crimes Act. Conflict of interest contrary to Section 42 of the same Act. Abuse of office contrary to Section 46 of the same Act. Unlawful acquisition of public property contrary to Section 45. Deceiving principal contrary to Section 41. Money laundering contrary to Section 3B1 as read with Section 16 of the Proceeds of Crime and Anti-Money Laundering Act number 9 of 2009. Acquisition of proceeds of crime contrary to Section 4 of Proceeds of